Hey, everybody. Welcome to the Breakdown and All Rise News collab. We don't have a Labubu, but we are here to talk about a hearing that well, first of all, it took 45 minutes, almost an hour to be able to get into this hearing because of technical difficulty. It was a hearing called pretty much last minute by Judge Immergut. And so I want to give a little now. We're going to see if Anna Bauer can join us in a little bit. I think she has to download the Substack app first. But let me set the scene. Okay. So it was yesterday, right, that Judge Immergut's ruling came out. And please, everybody, welcome Adam Klasfeld. So she issued a temporary restraining order saying there's nothing on the ground in Portland that justifies the calling out of the National Guard. And although she says, I don't have all of the briefing and all of the stuff, this is an emergency hearing. And in order to issue a temporary restraining order, I don't need all that. I just need sort of a first look. And her impression is that sending out the guard was just, the wrong idea under 12406, which is the authority, I think, that Donald Trump wanted to call it the Oregon National Guard with. I could be wrong on that, but you'll correct me if I am. So she issued a temporary restraining order saying there's no need for on the ground for the guard. There's like 6 people, and one of them's dressed up as a giant inflatable capybara. So no, we don't need the National Guard here. So that was yesterday. Then Donald Trump and the Trump administration, Pete Hegseth, called up already federalized Guard in California. These were guards that were National Guardsmen that were federalized in June to the response to the war-torn, war-ravaged nothingness that was going on in Los Angeles at the time. And that order still stands. So they just moved those already federalized guard to Oregon, and they were on their way. So then the lawyers for Oregon and California joined the lawsuit. California comes in. Gavin Newsom joins the lawsuit. Says, you can't take our guard. We need them for wildfires and stuff and our own stuff. We're California. Hey. And so and then Hegseth puts out an order that he got permission from Greg Abbott to deploy Texas National Guard to Oregon and Chicago. So now the judge called this late night hearing, emergency hearing, because California and the city of Portland and the state of Oregon are all, they wanted a second restraining order saying that the DOJ is just circumventing Your Honor's order because the order is grounded in the fact that the guard isn't needed. And since Your Honor said you blocked the Oregon National Guard, the DOJ exploited that by saying, well, we'll send California Guard and we'll send Texas Guard. And so we're playing a game of whack-a-mole. And I have to tell you, my impression is that Judge Immergut, who is a Trump appointee, is pissed off about this. And that's why she called this Sunday night, 7 p.m. meeting. So Adam, did I get any of that wrong, or is that kind of the gist?
That is 100% correct. And the way that you can tell that a federal judge is very angry, even if that judge doesn't raise his or her voice, is if they ask repeatedly if to respond as an officer of the court. Judge Immergut sent again and again to the DOJ's senior attorney, Eric Hamilton, did he believe, as an officer of the court, that the proper response to her order forbidding the federalizing of the Oregon National Guard was to send the California National Guard to Oregon? Hello there, Anna. Now we have the full panel with us. So I was going into the fact, and I'm sure that you will echo these remarks. It is never a good thing when a federal judge reminds a DOJ attorney that they're an officer of the court and says, you are an attorney, when they say, I am not a policymaker. It is.
Yeah, and that seems to happen a lot these days.
So everybody welcome Anna Bauer from Lawfare. Anna,
Hey.
I briefly summed up the order of events where Oregon National Guard was called out, They sued, got a restraining order. She granted the restraining order for the Oregon National Guard. Trump then called the California National Guard that was already nationalized back in June, federalized back in June. And then California jumped on and joined the lawsuit. And then they got Texas to call it the National Guard to not just Portland, but also Chicago. And that's kind of where we are. She called this emergency hearing. And so Adam was kind of going over a little bit of what I kind of took away from this. And you've done a lot of court reporting too. Well, she was mad. Mr. Hamilton, like multiple times. And as Adam just brought up, reminding him that he's an officer of the court. So everybody welcome Anna Bauer to the discussion. Hey, Ann.
Yeah, thanks for having me. And Adam, please continue. I didn't mean to interrupt you because you had a great train of thought there. I just wanted to remark that, you and I both go to these same hearings over and over again where it seems like I hear so much all the time, judges saying to DOJ attorneys who are probably not used to it, where the judge says, as a reminder, you are an officer of the court with an ethical duty, the implication being that they have an ethical duty of candor and honesty. But please, Adam, continue because that was a great comment.
Right. I mean, your point is absolutely 100% true. This is now a commonplace occurrence. It used to be an extraordinary dressing down when a judge would say, let alone to a government attorney, you respond as an officer of the court. Now it's a routine occurrence, just like it used to be an unheard of occurrence to say that the presumption of regularity has been destroyed. Now that is something that is becoming more routine. It's something that was said in the case of Kilmar Abrego Garcia by Judge Sinis. But to turn back again to today's hearing, one thing that I found very interesting is that while the state of California and the state of Oregon were asking to modify the temporary restraining order to include all of the 50 states and the District of Columbia, at a kind of request that accepts as a idea that it requires modification. The judge said again and again that the government's actions were in direct contravention to her original order. It's a subtle distinction, but it's an important one because what was brought before her was a request for a modification. She says, this is not a modification. This is encompassed in the original order, but I will put forward a second TRO.
Yeah, and I was reminded of another case because you brought up the Kilmar case. Judge Friedman said in just 6 months, the president of the United States may have forfeited the right to such a presumption of regularity. And Judge Chutkin said defense counsel is reminded of their duty to make truthful representations to the court, which is another way of saying you're an officer of this court, which is you guys were saying we hear a lot more often.
And even most recently, I mean, if you recall another emergency weekend hearing that we had that not, very different from this one in that it all happened within the span of, it came together within the span of a few hours, which was the case before Judge Suknanon related to the efforts by the Trump administration to essentially, take kids who are unaccompanied minor migrant children out of their beds at night and send them on a plane back to Guatemala. The judge who eventually took over on that case and was assigned the case is a Trump appointee named Judge Kelly. And most recently, in his order in which he granted a preliminary injunction in that case to bar the removal of those children, he effectively said, the government's representations, because they were making all these statements about, the kids are all children whose parents want them to be returned to them in Guatemala, making those types of claims. And again, it was a Trump judge, as this one is, who effectively called out the government. And I think that what we're seeing here is that over and over again, district court judges, but not necessarily the courts of appeal, are doing their jobs and paying attention closely to these facts and the patterns that are happening in which the government is, making representations that usually would be taken in good faith, but because this administration has destroyed the presumption of regularity, the judges know now that they cannot take those representations in good faith. And it's really remarkable because that is just not something that usually happens.
Right.
Yeah,
Right.
I have
No,
a question for you guys
right.
about the narrow reading that the DOJ had of Judge Immergut's order from her first one from yesterday, which feels like 10 years ago. Because what it said, I thought it was just going to be, oh, you just said the Oregon National Guard, nothing else. But what they're actually hanging this on, and Mr. Hamilton is the person who is arguing for the DOJ, and help me understand this, is that they're going off of an order to nationalize or federalize the California National Guard from June, saying they're already federalized and we can use them for whatever we need them for. And they're saying we need them in Portland. And that's why this is not in violation of your order yesterday. So not only is it just, well, you only said the Oregon National Guard. And I think what was really frustrating to the judge was she was like, the basis of my ruling wasn't where the guard comes from. It's based on the fact that there's nothing on the ground that warrants it. But why are they going with we're using already federalized guards or guardsmen from California as opposed to just a broader, well, we should be able to pull National Guard however we want because you only said Oregon's National Guard couldn't be deployed. What's the thinking there?
Well, it seems like two different species of hair splitting, because if you look at the original ruling, you have her blocking the memo justifying the activation of the National Guard, and they are calling upon a different memo, the earlier memo that activated the California National Guard, that wasn't limited in time and scope. But to your point, Allison, the whole idea was, and what the judge said, is that this is still in direct contravention of her original order because she was ruling because it violated Title 10 and the 10th Amendment, that she found that the circumstances didn't call for it. So it didn't matter which memo they were predicating it on. I wanted to echo one of the things that Anna said and kind of put kind of the big picture to the fact that we're all here now on about 15 minutes till midnight on East Coast time. The extraordinary becoming routine that these things now happen late on a weekend. It's happening on the July 4th weekend when we had the showdown in the District of Massachusetts in a major immigration case where the Trump administration fought for and got the right to whisk people away to a country in Africa that they had no connection to. It happened over the Labor Day weekend with the case that Anna alluded to. And these emergency decisions, it shows the judges stepping up at all hours, on weekends, on holidays, at the district court level.
Boasberg showing up in jeans and a T-shirt because he couldn't get his robes because he was there on a weekend to stop those planes from going to El Salvador.
Absolutely.
Yeah, I am actually in my pajamas right now because
Me too.
I did not expect to be on a live stream or covering a hearing at, past 10 o'clock at night on a Sunday. So it
That
does
was your
underscore.
post on Blue Sky, by the way.
Right.
You were like, oh, report for the courts, they said. It'll be great. You'll get your weekends off.
Everyone always says that, but it's never true. I mean, to be fair, it has not been true for covering the Trump trials and all of that. It's been, as you both well know, it's always crazy. You're always on call. But Allison, I think to your original question, I do think Adam is right that what I when I was looking at it, it feels a little bit like this idea of following the letter but not the spirit of the judge's order. Because if you look at the very last line of that order, as Adam pointed out, it does say that I'm entering a TRO, barring implementation of the memorandum that was issued with respect to the federalization of the Oregon National Guard. But the actual substance of the order relates to, as Adam already put it, to the conditions in Oregon and whether or not it's sufficient to trigger the statutory authority here. The judge found no. And so, taking all of those things, one would think that the government would have enough sense to say, oh, well, of course, if we follow the spirit of the judge's order, these same exact reasons would all apply to whether you send federalized guard from California or from Texas. But they did not do that. And I think that's why the judge was so unhappy with the government tonight.
Yeah, and I think judges are starting to change the way that they do orders, too. We saw a judge say in court now a couple of times, is my oral order enough for you,
Yeah.
or do you need it in writing? Because the way they tried to get around Boasberg's turn the plane around order is they said, oh, well, you just said that with your mouth and words in court. It wasn't in your written order, so we didn't feel we had to follow it. So now judges are like, is the words that are coming out of my mouth, do you understand the words that are coming out of my mouth? Is that enough for you? And they've had to say yes. So I imagine now we're going to start seeing judges, particularly in these guard restraining or temporary restraining order cases, being like, okay, so now I can't just say the memo. I can't just say the Oregon National Guard. If I have to say any National Guard or the DC National Guard, in order for my point to get across, because there's no presumption of regularity and y'all are a bunch of jerks, I'm going to have to change the way I issue orders. One more. Oh, sorry. Go ahead.
Oh, no, I was just going to add that, it is very much giving instructions to a kindergartner a little bit. That's what I think of whenever I see some of these judges dealing with the government now, because they see the experience that Judge Boasberg had where, there was a little bit of wiggle room in the order that he issued, although I don't think so on a fair reading, but obviously the DC Circuit, there's a whole backstory there, but basically it was enough to which at least 1 to 2 members of the DC Circuit saw it sufficiently ambiguous in that order regarding the flights to El Salvador, that he wasn't able to really hold anyone to account, at least thus far. And so a lot of these judges, I think, if they're paying attention, as I said, are trying to go to great lengths to try to really break things down to kindergarten levels of this is how you follow my instructions. This is what every single word or phrase in my order means, because they think that's the only way to ensure compliance. And they're not entirely sure that the appeals courts are going to have their backs if it does come to trying to ensure post hoc compliance or after the fact compliance.
Yeah, I was like, at first I would just ask my ex-husband to clean the kitchen, and that eventually turned into, okay, I need you to wash the dishes, wipe down the counter, lift up the coffee maker, wipe underneath the coffee maker, put the coffee maker back down, use soap. It gets a little bit ridiculous that you can't just trust the spirit of an order anymore. Adam, let me ask you a question, and Annie, you can chime in too, because this is something I'm a little confused about. The judge was asking toward the end of this hearing about what the Ninth Circuit is going to do, because the government has filed an emergency stay. Please stay this order with the Ninth Circuit Court of Appeals, and has filed the same with Judge Immergut, and asked for an administrative stay as well. And she was asking how, if she issued a modified order or if she issued a second order, how would that be impacted? How could her order or would her order be impacted if the Ninth Circuit granted an administrative stay or another type of a longer stay? So could you maybe explain that a little bit? And then also, there was one other thing I wanted to ask about. oh, the administrative stays. By the way, I was like, I thought the hearing was over. And then Hamilton was like, oh, one more thing. And I was like, oh my God, what? You want to continue to talk to this judge right now? He's like, yeah, what about our request for a stay and an administrative stay? And she's like, it's denied. Court adjourned. Like it was, whew, she was really upset. But can you answer that Ninth Circuit thing and how the difference between a second restraining order versus a modified restraining order? Because she was reluctant to modify her order.
Yes, so I think you just said it, Allison. At the end of the day, she drew the kind of subtle distinction of her original order she found was directly contravened. And so there was a violation of her original order. And so though there was a request for the modification of the original order, as I understand it, it got a little, there was a little bit of back and forth toward the end of the hearing. It came down to her issuing a second TRO that essentially clarified the original order. But what she said repeatedly throughout the hearing is there really isn't any daylight between the first order and the second, because the second order, the the government's actions already violated the first order. The second one is to eliminate all doubt. I don't know if you had a different takeaway, Anna.
Yeah, so if I could just chime in a little bit on the question about like how it relates to the appeal. Judge Immergut, is that how we're pronouncing her name? Immergut? Is that
I
correct?
haven't
Okay.
heard it pronounced. So I've been saying Immergut, but I
All
don't
right.
know.
Apologies to Judge Immergut if she is listening and I am pronouncing her name incorrectly, but that's what I'm going with tonight. So Judge Immergut's first order, of course, that just related to the federalization of the Oregon National Guard was then pretty much immediately there was a notice of appeal to the Ninth Circuit by the government. Typically, the way that jurisdiction or the court's power to decide a case, the way that works is that, like, basically, as soon as a notice of appeal is filed, the district court, which is Judge Immergut, is, divested or not allowed to hear the case anymore because it's now in the power of the appeals court to figure this whole thing out and decide the case.
You usually
So that
can't appeal a temporary restraining order, right?
Well, so there's also that issue as well, which I think we don't necessarily need to get into but there's a kind of longer story there about, like, usually you can't appeal a TRO or a temporary restraining order. Usually you only can appeal a preliminary injunction or above, basically. But in the Trump era, we have seen that a lot of appeals courts have construed or read TROs to basically be preliminary injunctions,
Okay.
and as such have taken the appeals, even though technically the orders are temporary restraining orders and not injunctions. But
And as a matter of
people,
fact, sorry, I was just
go
going to
ahead.
interject. As a matter of fact, that's exactly what happened with Judge Breyer's order in the Ninth Circuit. I'm sorry, Anna, I didn't mean to interrupt.
No, you're good. Yeah, that is correct. That's exactly what happened with the Judge Breyer order related to the California federalization of the National Guard. But what's important here is that as soon as that notice of appeal is filed by the government, typically it all kind of goes to the appeals court, and the trial court judge or the district court judge, which is again Judge Immergut, doesn't have any power to like do anything anymore. And that relates here to what was going on with issuing a new order as opposed to a modified order, because that original order was already at the appeals court, basically, by the time the second request for a temporary restraining order got to her. So that's why at the very end of the hearing, she was asking, like, how does all of this relate to what's going on at the Ninth Circuit? There's also maybe a different question as it relates to California, because there's separate litigation that is now on appeal to the Ninth Circuit. But just to make it a little bit less confusing for the non-lawyers, the basic issue here was kind of like, how do I have power to issue this order if, it's already at the appeals court? And the answer was, you can issue a new order. There are all these new circumstances, that kind of thing that
That's why
relates
she was
to.
concerned about modifying an order that was with the
Right.
Ninth Circuit. I see.
Exactly, because she can't modify it now because that's already at the Ninth Circuit. But the changed circumstances with the fact that the California National Guard, which is not the original circumstances of the initial order, and then also now the Texas deployment of Texas National Guard troops, which just came up minutes before the hearing. She was able to cite those two things as a reason to, issue a whole new order as opposed to just modifying the other
To
one.
have jurisdiction
Yeah.
back on something
Hmm.
like.
Yeah.
I'm seeing a number of commentators talk about fear for what's going to happen in Chicago and how it came up during. I just want to mention something about that because I see a lot of folks commenting about that. The one thing that did come up in the hearing was the possibility of sending the Texas National Guard to Chicago. I think one of the important things about public hearings like these show the limitations of Trump's power. Now, if you look at the Posse Comitatus trial in California, what we saw is that for all of Trump's claims that he's going to uh, deploy the military for use in civilian law enforcement during the trial in California, what was found out was that they detained people a grand total of 2 times. They violated the Posse Comitatus Act, Judge Breyer found, by trying to use the military for traffic control and other civilian purposes. But for all of the talk of the Trump administration, the second these plans go into action, we find that that according to a Reuters investigation in Washington D.C., the law enforcement activity in the city hasn't meaningfully changed over that time. So I think the public hearings here, that this isn't to minimize how unconstitutional and and how lawless a lot of these actions are. It's also to cast a realistic view on the limitations of Trump's actual power. And what the courts keep doing is showing how limited those powers are, even in a system of a very, very high deference to the executive over control of the military.
Yeah, and I think it's interesting that the government would choose to exploit, semantics in this particular case, rather than try to build a case to say that the situation on the ground in Portland has changed. I mean, it looks like the DHS is doing everything it can to be like, people are ramming into our cars and blocking us in. And I mean, it's a lot of it is unfounded, and we don't have the details on that yet because only the DHS is putting out these press releases. But it just seems interesting that it feels like one of those situations that, all three of us were covering during, the Trump investigations, where they would say one thing to the public and one thing to the court.
Hmm.
So to go
100%.
with the loophole that they only said the Oregon National Guard, and we already called up the California National Guard, and that memo is still good, and you didn't block that one. To go with that instead of to try to build a case to say, no, the situation on the ground in Portland has changed because it is a lot more dangerous. There is a lot more violence. It seems like they would have to prove that in court, and that would be a very tall order given the fact that, again, it's like 7 people and a person dressed up as an inflatable capybara at the ICE facility.
Well, and it's not just that you have to prove it in court, it's also that you have to have officers of the court who are willing to make that argument.
Sure.
I'm not entirely sure that I don't know much about Eric Hamilton, who was arguing tonight, but he certainly did not seem keen to go down that route, Allison.
Right.
So, that is at least notable.
Yeah, I think it
It
is too.
reminds me, to use your example, Allison, and your point, Anna. It reminds me of after the 2020 election, where you'd have Rudy Giuliani go up in front of Four Seasons Landscaping and talk about fraud, then he'd go into court and say this exact sentence. This is not a fraud case. Four Trump attorneys said that exact sentence in the wake of the 2020 presidential election. For all of this lying that there's such a thing about the Department of War, no, there's no such thing. If renaming of a federal agency happens through Congress, there's no such thing as a Secretary of War. There is no war on American cities. That is what is being said by this administration to scare the people of those cities, to intimidate the people of those cities from exercising their rights. I think it's a basic point that needs to be articulated that when these lawyers are put in front of a court to actually say what's going on and what the actual policy of the United States is purports to be, the messaging changes. They cannot lie quite as flagrantly.
Well, I want to thank you both. I am about to kind of give a little. I see a lot of questions about why only 14 days, what a temporary restraining order is versus a preliminary injunction versus a permanent injunction, and I'm going to probably do a little quick breakdown of that for everybody. But I just wanted to, before that happens, I wanted to say thank you. So, because you, Anna, Adam, you're free to go. You're dismissed if you would like, unless you want to stay around for my tro thing. But everybody, please follow Anna Bauer. She's got an amazing Substack called Slip Opinion. You're going to want to subscribe to it. And then, of course,
it has not launched quite yet, but it will one day.
Okay.
So stay tuned.
So get ready. And then, of course, All Rise News, Adam Klasfeld. And it's, obviously that it's free to subscribe. But if you can support independent journalism, please do. And also, support Lawfare, where Anna works doggedly with some incredible podcasting and writing and reporting for the courts. And you can support them as well. So thank you, Adam. Thank you, Anna. Do you have any final thing? The only other thing I want to say is I think it was interesting that while we were waiting about an hour to get into the hearing because of the technical difficulties, that all of us in this little universe were texting one another. Like I was texting with Kel at National Security Counselors, Anna, Katie, Fang, who's out and about and was listening and working hard because she works so hard. Adam, another friend of mine, I was texting with, and we were all sort of going back and forth, waiting to get into this hearing, and communicating with each other. And so I think that this community of independent journalists is just so important for everybody, so that they can get these like blow by blow on the ground things that it's so important to just be right instead of first. And you guys are just so good at it. So I just want to thank you so much for jumping on at all hours of the night on a Sunday to speak to everyone and to sort of explain what went down in this hearing, because it was a pretty remarkable hearing, I thought.
It really was. And thank you so much, Allison, for the same exact reasons. I know that no one works as hard as you. So I always appreciate your work. And I am going to exit because it is midnight here on the East Coast. Adam, fantastic as always. Allison, thanks again for having me. I appreciate it. And thanks everyone who listened.
Thanks, Anna.
Thank you. Thank you both. It's always a pleasure speaking to either of you, and so both of you at once is a real treat.